Good evening, ladies and gentlemen, and welcome to the Two Cities podcast. Today is the 6th Sunday after Epiphany, and I'm very pleased and honoured to be joined once again by my friend, Colonel James Bogle. Colonel Bogle, welcome back to the Two Cities podcast.
Thank you. Thank you very much for having me back.
Well, Colonel Bogle is a barrister in practice in Britain for 30 years in constitutional, public and commercial law. He is a former British cavalry officer and a writer and historian. He's also a Knight of Malta and was president of the International Una Voce Federation, promoting the traditional Roman rite from 2013 to 2015. He is also the former chairman of the Catholic Union and the current chair of the Orthodox Conservatives. Now, some mutual friends of ours, Father Thomas Crean and Dr. Alan Phimister, both of whom have appeared on this podcast before, wrote in their book, Integralism, a manual, the claim that the common law system is connatural to Christendom. And this is a claim that we are going to pursue and explore this evening. I've spoken before about how it's my belief that each Christian nation, formerly Christian nation, has a precious legacy or many precious legacies of Christendom, which function as obstacles to anti-Christendom. And I think for England and the wider Anglophone world, the common law is a great catatonic institution. This system is concrete, close to human life, and bound up with the realities of life, as Sir Roger Scruton put it. So, Colonel Bogle, could we begin by just examining the origins of the common law system and seek to explain how these two great parallel institutions of civilian law and common law arose, which both have their origins in Roman law?
Well, the first thing to say is that modern civilian law, so-called, meaning the Code Civil, isn't really the same as the old civilian law. The old civilian law is basically Roman law, based upon the law that obtained in the Roman Empire, both pagan and Christian, beginning, of course, with the 12 Tables, which goes back to the mists of time in the Roman Republic and monarchy. It was Christianized when, on I think the 27th of February 382, Christianity became the official religion of the Roman Empire under the Emperor Theodosius I. A lot of people think it was under the Emperor Constantine. That isn't correct. Constantine was the first to tolerate Catholic Christianity, and he himself later was baptized. Of course, in those days, the church was undivided, so everybody shared the same species of Christianity. And it was only under a couple of emperors later, under Emperor Theodosius I, that it became the official religion of the Roman Empire across the whole of the then known world. Most of the then known world. And out of that grew Roman law, which was then codified by Justinian around about the year 500, who was the Eastern Roman emperor, and that was the center of Christianity because the Western Empire fell in 476. And although Clovis, the king of the Franks, was baptized in 496 by Saint Remigius, and he then in due course made Christianity the religion of his empire, that was still a very small part of what had been the Roman Empire, the Christian Roman Empire from the time of Theodosius. And so the center of gravity of the Christian world moved to the east and centered on Constantinople. And that is where Roman law then developed and was codified by Justinian in his institutes and various associated documents the so-called Analects, I think, of Justinian. And that is really and remained the basis of Roman law, well, probably still unto this present day. But although that obtained both in East and West with obvious developments and growth over the intervening centuries, with various other developments added to the Roman law, that was eventually changed. We'll come on to that in a minute. But there was a bifurcation from the beginning of the Christian Roman Empire between the civil and the canon law. But both of these have their origin in Roman law. And to this day, canon law follows Roman law precepts more than it does any other type of law. The Roman civil law is what we now call the civilian system, and its doctrines we call the civilian doctrines to distinguish them from the English common law. But in fact, English common law also has its origins in Roman law. And essentially it developed out of the law that pertained and obtained in the Christian Roman world, but took a slightly different path. I mean, to be fair, the developments of Roman law in each of the constituent countries of Christendom took a path of their own, some more than others, so that there were specific Spanish characteristics in Spain and Italian characteristics in Italy, and Teutonic characteristics in the Holy Roman Empire of the German people, and the Frankish nation, which became France, and England and Scotland, and also Ireland, because in fact the Irish, up until the conquest of Ireland by the Anglo-Normans under King Henry II, I might add the invitation of King Dermot MacMurrough, the King of Leinster, who was in fear of his life from the other kings, and there was a dispute over who was the High King of Ireland, the High King being essentially an emperor himself. Up until then, the Irish had their own system, which was not based on Roman law. It was based on the Brehon laws, which were originally pagan. I mean, so was the Roman law, but they retained a lot of pagan elements, which Christianity took a bit of time to weed out, and sometimes with difficulty. So you can see there are various developments in various directions. And although there were distinctive characteristics that no longer exist on the continent, they do, the distinctive elements continue to exist in England for reasons I'll come on to in a moment. And that out of that, we have the development of the common law, the English common law. It's called the common law, but in fact it is characteristic of all English law systems. And the reason why it is influential to this present day is because of the British Empire, which spread the common law throughout an empire that covered more of the Earth's surface than I think most other, if not all other empires. Not 100% sure about that. The Mongol Empire might have covered a bit more territory. I'm not sure. But anyway, it was certainly well up there. But what happened is that the Roman law was trotting along perfectly nicely. And by the way, it has very similar, a very similar idea of precedent to the common law, which is, after all, where the common law gets it from, gets the idea from. And the force of custom becoming the law of the land, and various other concepts that continue to exist in English common law. And that is how it was until the end of the 18th century. And with the French Revolution, we then, of course, got the Napoleonic Wars, and Napoleon Bonaparte conquered most of Europe. he did not conquer England or Scotland or Ireland or Wales. Also in other parts of the extremities of the European continent, for example, Russia. But what he did was he authorized, he didn't actually write, some people say he wrote it, he didn't, but he authorized a version of law which was codified and which has come down to history as the Code Napoleon. And he imposed that on all the countries that he conquered. And although it is predicated upon Roman law and has its origin out of Roman law, it's actually very different in many respects from Roman law, largely because it was codified. Now, it is true that Justinian partly codified Roman law, but his idea of codification was to assimilate everything that had gone before, and in essence, to make a kind of compendium of the Roman law as it had been. Whereas Bonaparte's aim was revolutionary. He wanted to do away with the old Roman law because it was Christian and Catholic, and introduce a new code which would be freestanding and would be, as it were, the start of year one. Now, of course, you can't actually do that with a law. You've got to always be able to go back and refer to how we did it before. But out of that began the fashion, in some ways a rather retrograde fashion, for codifying the law. And because the Code Napoleon was a kind of revolutionary new code, subsequent codifications of the law, including, by the way, in England, have led people to think, oh, well, we now have a new code. We don't need to worry about what went before. That's a very revolutionary step to take and can have all sorts of very dangerous adverse consequences, as we'll come on to in due course. So that is what happened to the Roman law. It was essentially abolished by Napoleon Bonaparte. It was retained in the canon law, but even the canon law was eventually codified in 1917. Up until then, the canon law had many characteristics similar to the Roman law and the common law, in that it did not codify, although people would occasionally reclassify or compile the elements of the law, but it consisted of individual decretals or decrees of popes, councils, and bishops, which were forms of human positive law, ecclesiastical law, which carried the weight of being current law. But that's very different from a specific code of law. So one or two countries retained Roman law and still do to this day. For example, Liechtenstein still has a species of Roman law, although it's heavily overlaid by the Code Napoleon in many respects. And Scotland has Roman law, although it too is overlaid not by the Code Napoleon, but inevitably by statutes emanating from the British Parliament, which in turn tend to reflect the English common law. And so certain concepts that are essential to English common law find their way into Scottish law. But the Scottish law is essentially a Roman system. There are probably one or two other countries that still have, very small countries, perhaps San Marino or I don't know where. And the Russians have a different system again. Although it was originally Roman law, it was Slavified. And so the Roman system was developed in a slightly different direction from the Roman law, but it too has been codified. And so it suffers from all the defects that a codified law has. So the only system, or systems, plural, that continue to have grown and developed out of the Roman law, developed in their own direction, without interruption, let alone revolutionary interruption, are systems like Liechtenstein, England, Scotland, to some extent, the Netherlands, they retained elements of Roman law in more than did other countries in Europe. And of those, far and away the most important is English common law. And the reason for that is because it's, as I said earlier, it was spread throughout the world by the British Empire. So that's where the two, that's the origin of the two systems. So in a sense, the common law, certainly it's more so even in Scotland, but also in England, has a little bit more in common with Roman law than, in some respects, than does the civil Code Napoleon. Although the Code Napoleon directly derived from Roman law, because it was a codification designed to throw away the old Roman law, it necessarily has very significant differences. But modern lawyers refer to both of them as civilian systems and civilian doctrines, which I think is actually rather misleading, because there's the system that obtains in France, with its own peculiar developments of the administrative law, the droit administratif, or in Germany, or in Spain, or in Italy, or indeed other parts of Europe, is significantly different from the Roman law as it once was. And in many respects, in its spirit, the common law has more in common with the spirit of the old Roman law than does modern civilian systems. And the faults of the modern civilian systems are entirely their own and cannot be laid at the door of Roman law, as they often are, by English common lawyers who like to say, oh, well, we've got the common law and you haven't, so ha, 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 we're better than you are. Yes, we are better, but not because of Roman law, but because of Napoleon Bonaparte.
Mm-hmm.
So that gives you a bit of a summary of the origin of the two, if that helps.
Yes, very much so. I think that's a very important distinction to make, rather than conflating the post-revolutionary civilian law with pre-revolutionary Roman law. So the common law is inductive. The civil law system has been described as deductive. And the theories differ, but as you say, prior to the Great Revolutions, the content of the law was essentially the same in both systems, namely natural law informed by divine revelation. And this is something.
That's how it was before the Reformation.
Yeah.
The Reformation was another revolution that very radically affected English common law. Less radically, I would say, than the Code Napoleon, but nonetheless with a certain degree of radicalism. I think it would be fair to say that the Roman law, even though I've said it has more in common with common law in some respects than the Code Napoleon, it did have a little bit more codification than English common law. And the English lawyers developed a system pretty early on in Catholic times, long before the Reformation, of using what you rightly called the inductive method, rather than a system, rather than the Roman system. The Roman system, whilst it did have precedent, also had a place for legal scholars and legal scholarship. Whereas, although this wasn't always the case, the position now is that, up until fairly recently, is that English common law tended to have a very low view of the opinions of legal scholars. If you're a professor of law in France or Italy or Germany or Spain, then you're regarded as a potential authority to whom the courts can refer. In England, up until fairly recently, you weren't. You were just a writer of books. But English judges in more recent times have taken the view, well, we shouldn't, now that we're more, as they see it, more European, we ought to take cognizance more of what legal scholars say about particular points. And you'll find more references to legal scholarship in judgments than you would ever have done, say, in the 19th century, with some exceptions. And legal scholars have now been propelled one might even say, rocketed into the judiciary. For example, I think Mr. Justice Burroughs was a High Court judge and then bounced over the top of the Court of Appeal straight into the Supreme Court, having spent his entire life being a legal academic. So there is an attempt, I think, by the English common law now judges to pick up a few ideas from the continental system. Whether that's a good or a bad thing is a matter for debate. But so the Roman law system had a bigger place, perhaps, for legal academics than the English common law did. Nevertheless, there were legal texts like, for example, Sir John Fortescue, who's Lord Chief Justice of the King's Bench in the Middle Ages, wrote In Praise of the Laws of England. But it's not a book that is used to interpret the law, although it is occasionally referred to for that purpose, so much as simply a book by a very senior judge praising the English legal system. And so the English legal system tended to develop in exactly the way you said, by inductive method. In other words, more along scientific rather than philosophic, logical pathway and trajectory. And so the law would develop according to what the judges, having heard a case, arguments on both sides, if necessary, they would, if there was some dispute about what the law was, they would decide it, and that would then become the law, unless it was overturned by a more senior court. And that system of precedent has been very strictly adhered to, in theory, ever since. It was a little bit more flexible than that in the Roman system. As I say, the views of legal academics were taken into consideration. The fact that you had a Code of Justinian meant you could refer to the code, whereas in England, you had really no written constitution, and codifying law kind of provides a kind of constitution. But statutes from Parliament, and statutes were far and few between. There weren't that many, not like now where they're churned out like a sausage machine, to the enormous detriment of the law, I might add. They were quite rare. Now, statute is the highest precedent in the English common law system. But if we dig, and this is the point you were getting at, and I agree with you, if you dig back far enough, that is to say, before the Reformation, you'll find there are other sources of law besides just judges and statute. And those other sources of law, for all that they weren't turned into a code, passed as a statute, or specifically endorsed by judges as a whole, were nevertheless a kind of constitution. And by that I mean the doctrines of the church, the Bible, to some extent the canon law of the church, because you had in pre-Reformation times not only secular courts, but also ecclesiastical courts, the so-called courts Christian. And they decided issues which were regarded by English lawyers and by the English church, Catholic Church, of course, as the proper province of ecclesiastical courts. And they were libel, divorce in the sense meant by the Middle Ages, which is not the same as now. So libel and defamation, one or two others. I think probate, but chiefly infringements of the law of the church that were not also infringements of the law of the land. And it also took into consideration what even now is still called benefit of clergy, which does not mean, as the Catholic newspaper, The Tablet, seems to think, having a priest to hand when you need him, like on your deathbed. The number of times I've written to The Tablet and said, that is not what benefit of clergy means. And they just take no notice. Or at least if they do, they don't pass it around. Benefit of clergy meant that you were a cleric, and therefore you could not be tried by the secular criminal courts. You could only be tried by the ecclesiastical courts. And if the ecclesiastical courts defrocked you, then next time you committed the offence, you could be tried by the secular courts. It varied from country to country. In some places, certain offences were made by the law of the land, triable by the secular courts only. And in other countries, if you were defrocked by the ecclesiastical courts, you can be tried by for the same offence by the secular courts. But you couldn't in England. It's one of the long-standing principles of the common law, which unfortunately has been broached in our time. But a very, very ancient principle is that you can't be tried twice for the same crime. Now, and I should just add in passing that benefit of clergy caused a lot of problems. There's a famous statute, I think it was called Clericis Laicos. There's also a papal bull of that name, which was all at the time of the investiture contest between Pope and Emperor over who appoints bishops. There were similar problems between King Henry and Thomas Becket, which resulted in the constitutions of Clarendon, I think. Now, I'm dredging out parts of my memory now. But Thomas More defended the right of clerics not to be tried by the civil courts. But the problem with that is that you might have a parish priest who committed a murder, was tried by the ecclesiastical courts, and even if he was found guilty and not handed over to the secular arm, because there were certain offences that you could be tried if it was sufficiently serious by the secular courts. There he would be back in his parish saying mass again after having murdered somebody, perhaps a parishioner. That was bound to create problems. And those sorts of things resulted in the investiture contest, the contest between church and state, which was ultimately resolved by 1122. Can't remember which treaty it was.
The Diet of Worms?
Diet of Worms, I think it was, yes. And something similar in England with the constitutions of Clarendon. There were obvious difficulties. Difficulties were bound to arise in a system that is bifurcated in that way. But equally, it meant that each of the systems derived certain principles from the other and developed. And as they developed, they incorporated some of the principles. So the English common law, which itself originates in Roman law, derived certain other principles from the common law. And there arose a movement at the time of Henry VII and went on into the time of Henry VIII. And it was really a system, I suppose, a movement arising out of the Renaissance with the rediscovery of a lot of lost Greek and Roman texts, including political texts, which interested English lawyers and English politicians in Roman law all over again. And there was this movement was called the Reception, and it very nearly persuaded Parliament to reintroduce Roman law into England. The common lawyers rose up against it and happily defeated it, or unhappily, depending which way you look at it. And the Roman law was not received back into England in its then current state, and the English common law continued to develop as it had done for the previous centuries. So a judge in medieval England who refused, and I don't know of a single one who did, or even of would, refused to recognize the teachings of the church as influencing his judgment, or the Bible as a source of authority, or the canon law of the Catholic Church insofar as it impinged on secular matters, wouldn't have been a judge for very long.
Mm.
Because everybody would have risen up against him, but most importantly, the king, parliament, and the senior judges, and he would have been booted out on his backside pretty quickly. But I don't know of any judges who ever even contemplated doing that. It was just so much a part of the warp and weft of British society and of the whole of European society that the idea was completely unthinkable. So therefore, the development of the common law at that stage was reasonably restricted to what we would now describe as human positive law. That is to say, those areas of the law which are legitimately the province of human legislators, and not, as we now quite clearly have, outside the province of human legislators, because you're talking about natural law or divine law, neither of which can be overturned by human legislators lawfully, morally, or without the most disastrous consequences.
Mm.
And people in the Middle Ages, even though they differed over lots of ideas and concepts, including legal concepts, would not have questioned that for a minute. If anyone had said to them, "Oh, I think we should ditch the Bible and adopt the Analects of Confucius or the Sharia law of Islam," they just would have looked at you as if you had two heads.
Quite.
It just wasn't going to happen. However, as the Protestant Reformation began to get off the ground, then you started to get people dissenting, not from the idea of having church doctrine or the Bible, or even to some extent the canon law, as influencing the common law, but over interpretations of the Bible and interpretations of church teaching.
Mm-hmm.
And that created, of course, potential dissent, which originally was put down fairly ferociously by the English Parliament and the English judges. So much so that it culminated in the 15th century in a statute called De Comburendo Heretico, on the burning of heretics. And whilst the early church was very much against capital punishment for heretics, by the time of the Middle Ages, it had become a topical problem because, I'm talking about before the Reformation, you had, first of all, incursions by Islam, which very nearly wiped out Christendom, together with incursions by pagan tribes and by Vikings. And secondly, because heresy, meaning radical departure from the fundamental Christian basis and constitution of the state, threatened the whole state.
Mm-hmm.
It wasn't just, as now, a purely academic interest that threatened the church, but didn't really have any direct impact on the state. Well, I'm talking about theological heresy.
Mm.
It had a direct impact on the safety and security of the state. So once you do that, then you can expect the state to respond with fairly draconian responses. Any state will do that.
Quite.
And if anybody doubts that, then let me quote from Lord Phillips, Nicholas Phillips, who was the senior presiding judge in the UK Supreme Court and its previous manifestation, the Judicial Committee of the House of Lords, who, in a lecture, I think it may have been in a paper, was of the opinion that whilst everybody was abnormally opposed to torture, there might be an argument for it in certain cases when you're dealing with terrorists. You wouldn't have thought any English judge would ever have said that. Uh, because it's always been highly abhorrent to English jurisprudence since probably the 18th century, the late 18th century. Before then, of course, it was a very different matter. We can come back to that later. So he gave the example of supposing you have a classroom of young children in there, say 8, 9, or 10. There's a bomb been placed under there. You have the terrorist in captivity. He won't give you the code to decode the bomb. And Philip said, maybe that's a situation where torture to obtain that number would be allowable. So there's an example of how when circumstances change and the safety of the state is threatened, much more draconian measures are entertained. Modern scholars frequently leave that out of account when judging the past. They're quite happy to do it in the present, but when they look back at the past, they assume that, in the past, everything was very different. And so anyone who was in favor of torture was obviously an utter monster. Well, not necessarily. If you're going to call them a monster, then you must also call Lord Phillips a monster, and they don't, because he's regarded as a liberal. But as somebody once said, liberals are often very far from liberal. They can be extremely illiberal. But that's a different question. So we look back then at that period, and we see the growing development of various Protestant groups, or shall we say dissenting groups, like the Lollards, or the followers of Wycliffe, the Albigensians, or the Manichees, or the Valdensians, and particularly the Albigensians in France. I mean, first of all, one isn't told, but they murdered every envoy who was sent to them, beginning with prelates, and then bishops, and then archbishops, and eventually a cardinal, I think. Well, how was the Orthodox Catholic Church supposed to react to that? Oh dear, he killed the cardinal. Oh, well, sorry, cardinal, we can't do anything about it. Well, obviously they're going to defend themselves. So when it comes to the defense of the state, you can expect certain measures to be taken that in ordinary times might be regarded as unduly draconian. So we have to bear that in mind as well in the development of the law. We can't just look back and say, oh, they did horrid things, and therefore they were wrong, period. It's not as simple as that. Same applies, of course, to the Muslim invasions of Europe. And as I say, together with all the other invasions going on, in the 8th and 9th centuries, Christian Europe was on the point of eclipse. There was nothing in Italy beyond the Duchy of Rome and the Papal States. There was the Kingdom of the Franks and England, and everything else had been taken by pagan barbarians or by Islam. And then later, of course, the whole of Spain was taken. Well, actually, no. Umayyads, or the Abbasids at that stage, had taken the whole of Spain and got as far as Tours in France. So against that background, the law will develop in certain directions which may be undesirable and only temporary, but which have to be factored in. Then you get the Protestant Reformation, and then you have a very significant impact on English common law. By then, the English common law had a very distinctive character from law pertaining in the rest of Europe, which was all Roman law. Although there were a lot of things in common, not least Christianity, the Bible, certain principles of Roman law, doctrines of precedent, and so on, the natural law. There were also, within the narrow ambit of human positive law, there was a system that the English were very proud of, and I think rightly so. The English common lawyers then got too big for their boots. And when the Protestant Reformation was in the offing, they then you can see how it would have happened if you're a Protestant who thinks the only authority is the Bible and my personal interpretation of it. There is no authentic teaching office. No pope or bishop can tell me what the Bible means. Historical tradition as to what the Bible means. Previous church councils, whilst maybe moderately helpful, they're not authoritative. I decide what the Bible means. Gives a very subjective flavour to what was once an objective constitution in England. So what do you turn to give you a firm and stable base for your legal system, which every legal system needs? It can't just be, oh, this is my personal interpretation of the law based on the Bible. Yeah, I mean, that would be instant anarchy. And of course, in some parts of Europe, it became anarchy. So when you had the revolts in Munster,
yes,
and the Anabaptists and the various other extreme Protestant sects who said, well, the Bible says that if you're a Christian, you need no law because you just follow the law of God as you understand it. And they took that to mean that all law was imposed by the state was a monstrous imposition on Christian freedom. Some of them even went to the extent of being a kind of early communist.
Mm-hmm.
Rebellions, uprisings, and revolutions with the aim of abolishing statute and historic sources of law, like the parliaments. The result was a bloodbath, chaos, disaster, war. Unsurprisingly, it doesn't take a genius to work out how that was inevitable. That didn't happen in England. In England, the common lawyers said, we have the common law. That is our substratum. It's based on the Bible, the church's teaching, historic tradition, parliamentary statute, the wisdom of judges, Christian judges. So we can rely on that. And within that, we can have our own interpretation of what the Bible means, so long as it doesn't contradict the historic traditions of the canon law, of the common law. So that saved England in some respects from a lot of the troubles that occurred in areas where there was much more extreme Protestantism. And it gave an aura to the common law which already existed, but multiplied it many times over. And so you get then a different form of conflict, because you no longer are in direct conflict with, say, the teachings of the church, with the hierarchy of the church, the Pope at the top, or even the historic canon law, because, of course, the Church of England has a canon law as well, which is entirely based upon the Catholic canon law, but developed its own way. But it still has a lot of remarkable similarities with the old decretals of the Catholic canon law. So you no longer have that kind of investiture contest, potential conflict. That's gone because you got rid of the Pope and the church. The king is now the head of the church through his deputy, the Archbishop of Canterbury. So a different kind of conflict developed, which found its, I won't say fruition, its apogee. That's wrong too, because it wasn't a peaceful thing. It was a bellicose conflict in the 17th century between the king and the Puritans. Pardon me while I just wet the whistle. The Puritans were opposed. Well, I mean, you know what the Puritans were. They were the more extreme variant of Protestant in the Church of England. And by now, of course, in Scotland, since the 1560s, you now have a separate Scottish church, separated from Rome. By the way, they still had bishops then. They managed to get rid of the bishops until really after King James I. But the Presbyterian wing wanted to get rid of them because they didn't believe in bishops. And you started to get, with this conflict between the common law on the one hand and the Lord Chancellor's court, whose system, sources of law, were not the same as the common law. They weren't based upon judicial precedent overlaid by statute. They were, of course, overlaid by statute, but they had their own doctrines, the doctrines of the Court of Chancery, called the Court of Chancery because it was the Lord Chancellor's court. And a lot of common lawyers would poke fun, and this is including before the Reformation, at the Lord Chancellor's court, because the nostrums of Chancery, or the doctrines of Chancery, were thought by Chancery practitioners to override the common law, to supplement the common law, where the common law was too rigid, or didn't address an issue, or didn't address it in the right way to achieve justice. And so they said, well, that's what the Chancellor's Court is for. It's a court of conscience, rectify the rigidity of the common law, where the common law has said, well, we have this precedent, that precedent, that precedent, we must follow them. But, says the other litigant, but then you're going to get this result, and that's obviously unfair. Now, that became very important after the Reformation, because before the Reformation, you could solve that problem within the common law court without having to go to Chancery by making reference to the natural law, or to the Bible, or to the teaching of the church, but principally the natural law. You could say, but my lord, the result would be unnatural. It would be contrary to the Ten Commandments. It would be a form of theft, or it'd be a form of giving into the covetousness of your neighbor, or whatever, or any of the other sub-branches of the natural law. And you could appeal to theologians, and you could appeal to the teaching of the church, and the judge would take cognizance of it. Not after the Reformation. Gone. Because the Protestants didn't believe in an independent, freestanding natural law. They didn't believe that there was the eternal law of God, which bifurcated into the divine law and the natural law. And the natural law is written in the hearts of all men, whether they be Christian or not. The divine law is taught to the hearts of all men through missionaries, through the church, through scripture. And the two are entirely compatible, but different. Protestants said, no, there isn't such a thing as a natural law. There's only divine law.
Yes.
And it is mediated by my own conscience from reading the Bible. Bound to be a problem when it comes to creating the law and interpreting the law. So natural law is now gone. So that then increases the ambit and importance of the Chancellor's Court very considerably. Because what happens if you get something which is actually contrary to the natural law, but you can't argue that it is to the court, because the court no longer recognizes the natural law. And you can't find a precedent in common law that says you can't do that. We've found 3 precedents that says we can do that. And so you then have to get a writ, as they call them, an Anglo-Saxon term meaning something written, to take the case out of the common law courts. The common law courts were the Court of King's Bench and the Court of Common Pleas. And I think the Court of Exchequer, I may be wrong, Court of Exchequer may have been a Chancery Court. I should know this, I can't remember. To the Chancellor's Court and say, as a matter of conscience, my Lord Chancellor, this is unfair. And the Lord Chancellor, exercising his own conscience, will then say, yes, you're right. And out of the exercise of the Chancellor's conscience, which in pre-Reformation times would have been informed by the natural law, by the Bible, and by the teaching of the church, certain doctrines of Chancery developed, like delay defeats equity, equality is equity. But there are a whole series of Chancery principles and doctrines which had developed from the Middle Ages in the Catholic times and continued over into the Reformation times. But they now took on a life of their own as fundamental principles independent of the natural law, the Bible, and the teaching of the church. And even in the time of the 17th century, there was still an element also of the discretion of the Lord Chancellor to exercise his own conscience. Common lawyers objected to that, partly because they were common lawyers and thought the common law was the best thing going, but partly because a lot of them were Puritans.
Mm.
And they thought that the Chancellor's exercise of conscience was too arbitrary. And so they quite an old joke about the Court of Chancery was, well, how do you measure justice in the Court of Chancery? Answer, by the length of the Chancellor's foot. In other words, they were saying it was arbitrary and depended upon who the Chancellor was. You know, he might decide that, yes, I agree, that's unconscionable, but that isn't. So recognizing that this was a problem, the Court of Chancery then began more and more and more to rely upon the doctrines of equity. And out of that developed, it had its origins before the Reformation, the contrary or the balancing form of or source of law known as equity, which is the principles established originally in the courts of equity, of which the principal was the court of the Lord Chancellor. And to give you an example, all of these now still, I won't say binding, they are equitable doctrines upon which the courts of equity depend. Nowadays, since 1875, all courts are common law courts and equity courts. So they can apply common law equity as they see fit. But to give an example, and these are called the maxims of equity. Equity looks at done as that which ought to have been done. And then there's a whole series of cases going back to goodness knows when, including, well, perhaps not before the Reformation, but some very old cases, which explain in more detail what that means. And that in turn, based upon the principle of precedent, the maxim stare decisis et non quaeta movere, became a kind of common law of its own, or at least a binding precedent of its own, but a little bit more flexible, fluid, because the principle is what you look at. Then you look at the cases to tell you what the principle means. And if there's any flexibility left, the judge then exercises his own conscience, which one hopes will incorporate and include the natural law, but may not. Actually, the courts of equity tend to be rather better at it nowadays than some of the other courts. Equity, just a few other examples of the maxims of equity. Equity will not suffer a wrong to be without a remedy. Common law might have had, because it's strictly based upon previous precedent, you might have ended up with a wrong with no remedy. The Chancellor would say, well, that's unconscionable. We can't have that. And so equity is seen as, and the principles of maxims of equity are seen as a kind of court of conscience to restore justice where the common law hasn't been able to provide it, because it's too rigidly stuck to principles of precedent. Equity will not allow a wrongdoer to profit by a wrong. Equity does not punish. What it does is decide the remedy between two parties. Equity is a kind of equality. Often half each is equity. Not always, but it's a good starting point. But one who seeks equity must do equity. This overlaps with a very well-known principle of equity, which is he who comes to equity must come with clean hands. So if you have done something bad in this case, which compromises the other guy's remedy or justice, then don't expect that the court will allow you the justice that you have denied him. A perfectly fair and reasonable principle. Delay defeats equity. Equity aids the vigilant, not the indolent. A famous principle in equity of laches, a French word meaning delay, lâche. But in English, it comes out laches. So although there is a statute of limitations for which most causes after 6 years you're too late, the equitable doctrine of laches means that you might find that the judge says, no, I'm not going to say you're out of time, you're not out of time because you haven't reached 6 years. Actually, you should have done it much quicker. It's pretty rare that happens. Usually equity follows the law. There's another maxim: equity follows the law. So equity will go with the common law unless it's necessary not to. Equity imputes an intention to fulfill an obligation. Equity acts in personam, i.e., on persons rather than objects, and so on and so on and so on. These are all the equity doesn't, well, neither does the common law for that matter, act in vain. Equity will not assist a volunteer. That's another good one. In other words, if you haven't paid for it, you can't expect to be treated in the same way as if you had. So those are if you like, the moral debates that would have occurred in the medieval common law courts, which would largely have centered around, well, what does the Bible say? Well, what does the natural law say? Before then moving on to, well, this is not an issue of morality, the Ten Commandments, the natural law, or the Bible, or divine law. This is just this chap's boundary between my land and his is here, and he's moved it over to here. Well, obviously, there is an element of morality there because it looks like theft of land. But where the boundary should actually be isn't, strictly speaking, an issue of morality, natural law, or divine law. It's genuinely an area of law which is purely within the province of human positive law. It's a matter for the judge to decide. That would all be decided by the common law on the basis of precedent, and if the common law didn't get a just result, go to the chancellor and exercising the maxims of equity and if necessary, what is or is not conscionable. But as soon as you talk about conscionable, you're beginning to move into the area of morality. That will then be decided on that basis. Now, once you've got rid of the natural law and the Bible and the church's doctrine, you're then going to find that the debates between equity and the law, as we call it, the common law, sometimes common laws will refer to the common law as just the law as opposed to equity and the law, becomes much broader and wider because suddenly you find that the law and equity are now fighting each other over issues of morality, the natural law, divine law, conscience properly so designated. And that's what happened in the early 17th century. And it was inevitable. It was inevitable that once you got rid of the church courts, the common understanding and interpretation of the Bible and the natural law, that you would have a fight between branches of the law and between denominations, Christian denominations, between different theologians, and between lawyers and the king. And that's what happened in the early 17th century.
Yeah, and an example of that was when commoners who were uprooted or denied access to the commons through enclosure made appeal to the chancellor, the keeper of the king's conscience, to dispense equity. And the court of the Star Chamber was dispensing equity in favor of those dispossessed commoners, which antagonized the Protestant landowners who, as you say, would make appeal to the common law and criticize the arbitration of the king, and would go on to form a kind of oligarchy which would form the parliamentarian cause.
That's absolutely right. And that's a very good example. Chesterton referred to the Protestant Reformation as the revolt of the rich. And William Cobbett did the same. And Cobbett lived all his life an Anglican and died an Anglican and said he was going to be buried next to his parents in an Anglican churchyard. And yet, if you read his book, The History of the Protestant Reformation in England and Ireland, you never read a more savage indictment of the Protestant Reformation. No Catholic that I know of has ever written more savage an indictment than William Cobbett. I think partly because he felt, look, I'm an Anglican and this is what we've done. I feel embarrassed for my own church. And so he wrote this very scathing book, and he goes into considerable detail about the elimination of the commons. Now, one of the backbones of not only the system in England, but also across the entire continent in the Catholic Middle Ages, going right back to Roman times, and is a development of Roman land law, was the feudal system. Now heavily mocked by modern scholars, historians, and lawyers. But in fact, it was a very just system in many ways. It's been so distorted by modern historians that people just simply don't understand how it works or how it worked in its time. And the assumption is that it's a small number of greedy, rapacious lords crushing the rest of the population into dire poverty. And nothing could be further from the truth. The feudal system, under the guidance of the Catholic Church, eliminated slavery. Slavery existed in the Roman Empire. Christianity eventually got rid of it, and that was what resulted in the feudal system. But even in the early Christian empire, Roman Empire, you still had slaves. Now, the other thing you have to bear in mind is that slavery in the Christian empire and in the Roman Empire is very, very different from the kind of slavery we're talking about in the United States of America and southern states. In essence, it meant a form of indentured servitude. And the reason that it developed, and by the way, all those atheists who say, oh, the Bible's evil. Why? Well, because it endorses slavery. No, it does not. The Hebrew word is eres, and that is properly translated indentured servitude. Why did they have it? Because they didn't have prisons, let alone supermax prisons, such as America now has, which many people would argue is a nastier fate than being an heiress in the Old Testament, to be locked up in a supermax prison. Because they had no prisons, what were they going to do with prisoners of war? What were they going to do with very serious criminals who were not executed? Well, the answer was they put them into indentured servitude. And in the Bible, unlike many other legal systems, every 50 years they were all freed. It was called the Year of Jubilee. So it's very, very different from what the likes of Sam Harris and the late Christopher Hitchens and others claim is the endorsement of the Bible. It's not what the Bible endorses. And in the feudal system, whilst they still had this system of serfdom, serfs were not indentured. It wasn't indentured servitude. Yes, they were tied to the land, but in those days of minimal transport by our standards, horse and cart at best, nobody was really anxious, to run away to Scotland. You stuck with your local community. So being attached to the land wasn't as anything like as big a punishment as it would be nowadays. And in any case, even then, you would be permitted to make a pilgrimage, and it could be, to Rome, for example. So, the idea that people have developed the feudal system is very wrong. What the essence of the feudal system, which was the basis of English land law, both equity and the common law, was a system where the land was owned in common. It sounds communist almost. And in a sense, there's an element of that there. But the trustee was the king. And he parceled out the land to his principal followers, who were the tenants in chief. And they held land from the king, who in turn held it on behalf of the whole community, so long as they fulfilled their feudal duties, which were to provide an armed force to defend the country, and there was a set number depending on how much land you had, to provide a local administration or bureaucracy. Note, local, not national. Everything was decentralized, distributed, and subsidiarized in those days. And thirdly, a judicial system, again, local. So you had a whole network of local courts, of local administration and local authorities, all admittedly under the landholder, who would be a nobleman in the realm. And it cascaded all the way down through minor nobility to the smallest unit of the feudal system, which was the knight's fee. And the knight held that land in return for, and depended on the value of the land, because land in an agricultural economy is the prime source of wealth. How much your land was worth determined whether it was a knight's fee or a baron's fee or an earl's fee or a duke or whatever. And the knight, in return for £20, I think, was the value of a knight's fee. Lot more valuable in those days than it is now, obviously. He had to provide, I think, a constabulary of, I think, 10 other knights and some soldiers, a local administration, which would be administered by a reeve, known as the Shire Reeve, which later became sheriff, and a local judiciary. Well, for a knight's fee, the Shire Reeve was also the local judge, and so on and so on, up and down the system. And then you had various other forms of tenure. So you had grand sergeanty and petty sergeanty, which was, but grand sergeanty, for example, was typically used for ecclesiastical establishments. They couldn't fight, so they couldn't, although some of them did provide armed forces. So they would provide ecclesiastical services, saying masses, prayers, but also more material things under a system of grand sergeanty. Petty sergeanty were smaller versions of the same thing. You also had free and common soakage, which, by the way, is the basis now upon which everybody in this country holds their land. We hold our houses in free and common soakage. But that began when people who had accumulated a certain amount of wealth didn't want to provide an armed force. And by the way, if you had to provide an armed force, you had to command it. That is the origin of our local nobility and gentry leading their own yeomanry and soldiers into battle, because that was the feudal obligation. So much was dug into English culture that it is stuck there even to this day. Landowners out in the country even now feel a certain obligation to lead their own people in battle if they have to defend the country. So you had that, and you had some people who said, I'll pay the king or my immediate landlord a certain sum of money every year, a rent, so that I don't have to do anything else except keep the land. And they had various names for these kind of freeholders. In Chaucer's Canterbury Tales, he's called the Franklin, meaning a free owner, who is kind of poised between, I suppose he's what later would have been called a gentleman, the lowest form of the gentry. Next one down from him is a yeoman farmer who would be a tenant, an unfree tenant, meaning that he had less rights and obligations than somebody above him. And that system, the system that produced the Franklin, is now the system that we all have. We are all Franklins. We all own our land, provided we are a freeholder, in free and common soakage. If we don't own it in free and common soakage, we're no longer feudal subtenants owing obligations to our lord in the form of administrative, military, or judicial, or in the case of the peasants, working with their own hands on the Lord's land. But if we don't have that, we now have what's called leasehold, or a term of years absolute, which means that we only own, we only occupy the land as a rentler, if you like. Now, of course, everybody was a rentler in the feudal system because land was owned from the king, who was the principal trustee. And that system continued long after the Reformation. It wasn't really abolished in England until 1662 with the Abolition of Feudal Tenure Act. Oh, well, what was it called? Was it the Abolition of Feudal Tenure Act? I can't remember. And in Scotland, whilst in 1747, after the Jacobite uprising, the Heritable Jurisdictions Act 1747 got rid of a lot of the powers, the feudal powers that continued to exist in Scotland, but not in England. It wasn't fully abolished until 2002 with the Abolition of Feudal Tenures Act, Scotland 2002. So that's how long-lasting, how dug in, and how workable the feudal system was. And yet it is probably the system that is most abused by scholars and historians around the world to this day. And yet it lasted and made such a profound impact upon this country and this society, and indeed the whole of Europe, more than any other system we could ever think of. So there must have been something to it. And it produced, and this is something that's also not well known, the unfree tenants, the peasants, the villeins, the cotards, and various other names that they gave them in the Middle Ages. Many of them became very wealthy and lived a very comfortable lifestyle, particularly in Germany. When we talk about the peasants' revolt in Germany, we're not talking about a peasant in the sense that you and I mean at this stage, which we tend to mean by that some sort of agricultural labourer with straw sticking out of his hat. No, the peasants in those days were quite wealthy. And when they saw, at the time of the Reformation, either that their rights were being taken away from them because of the Reformation, or because they wanted more rights because of the Reformation, they rose up. So we get a very false picture of what is meant. And we use the word peasant in a derogatory sense. It's not a derogatory word on the continent.
No.
Paysan is a word that warms the heart of your average Frenchman. Paesano in Italy. I don't know what the German equivalent would be. It's not really farmer. But, farmers are highly regarded on the continent. Clearly not here, judging by Sir Keir Starmer's latest attack on our farmers. So a better word to use in England is yeoman. Yeoman farmer, because that's more the equivalent of what the French mean by paysan and the Italians by paesano. And I suppose the Germans would call them Bauern, but Bauern in Germany, meaning farmer, can be a little bit more derogatory than paysan or paesano. These are things that are not known. And this is why somebody like Sir John Fortescue, Lord Chief Justice of the Court of Common Pleas, wrote his book in praise of the laws of England, De Laude Legibus Angliae, because the feudal system had produced a very comfortable, wealthy, not comfortable by our standards, but comfortable and wealthy by the standards of most countries of the time. And he was justly proud of that. And he said, look, it's partly due to the customs and laws of England, by which he meant, of course, the common law, but the common law as it was interpreted in the Middle Ages, in a way that didn't run counter to the natural law or the Bible or the teachings of the church. And he was justly proud of that. And Cobbett writes extensively about how he was right to be justly proud. Cobbett does a little analysis of what you could buy just before the Reformation, in the time of King Henry VIII, and 200 years later, you went from a basket of goods that were well within the purchasing power of just about anybody, including, flesh, wine, butter, eggs, cheese, everything that you needed to the 18th century, when the ordinary people of England were starving to death. And in Speenham Land, according to the Speenham Land report, were living on cold water and potatoes. So which is the successful society?
Mm-hmm.
It's to Cobbett, it's obvious. And he then gets into the business of financial chicanery and usury and all those things that came in after the Protestant Reformation. So you saw a wealthy society ruined by revolt. And as both he and Chesterton put it, a revolt of the rich,
mm-hmm.
who by now were very, very rich and wanted to become richer. And the way they did it was they staged a revolution. And that revolution impoverished the poor, or made the rich richer, but at the expense of the poor. Whereas if they'd stuck with what they got, everybody would have been wealthier. The sort of thing that politicians dream of in the 21st century. How do we make everybody wealthy? Well, go back to the Middle Ages and see how they did it.
Mm-hmm.
And then you might learn a lesson or two. But don't go to all those philosophers of the Protestant Reformation, because what they produced was a disaster for the ordinary people. Now, having said that, at that middle period, from the Protestant Reformation until it began to settle down, was a system in which the law was, it has to be said, I think, somewhat perverted away from its beneficial impacts that had been building up over the centuries of the English common law. Partly, and probably largely by statute, interference by people like King Henry VIII, Queen Elizabeth I, to impose their new Reformation upon the whole of England, suppressing the monasteries, which were the private social welfare of the poor.
Mm.
You didn't have whole areas of the courts and of law devoted to arbitrating, and often very arbitrarily, social welfare, as you do now have, with first-tier tribunals and second-tier tribunals and appellate tribunals, all deciding, should we give widow Twankey another fourpence halfpenny a week? You had monasteries, which were peopled, manned, and womaned by individuals who gave their whole lives free to serve the rest of humanity. And so there was plenty for everybody. And so if you fell on hard times, down to the local monastery you would go. They would feed you, clothe you, look after you, put you back on your feet, employ you. This was a whole system throughout the whole country of social welfare that was just abolished by Henry VIII. And he gave all that money and all the land and all the buildings to his favourites among the aristocracy, the revolt of the rich. And that is how families like the Russells, from being nobody, became fabulously wealthy and eventually at the top of the aristocracy. Now the Duke of Bedford, although he is, I'm sure, a jolly nice chap. His antecedents were less nice, it has to be said. So during that period, you then, having created this revolution, inevitably, you're going to have fights between Parliament and the King, between common lawyers and the Chancery courts, between differing factions within the church. It's all one big boiling mess that is bound to, and eventually did lead to, a civil war. Mm-hmm. And at that time, you had famous common lawyers like Sir Edward Coke, spelled C-O-K-E, against people like Francis Bacon, the Earl of St Albans, or was he made a duke in due course? Can't remember. Lord St Albans. St Albans representing Chancery, and Coke representing the common law. St Albans more of an Anglican in the middle, or perhaps higher version of Anglicanism, and Coke very much a Puritan. And Coke developing and writing in his famous Institutes that the common law is the perfection of reason. This was Sir Edward Coke. Well, now, look, I'm a common lawyer. I'm very much in favour of the common law, but I'm not going to pretend it's the perfection of reason.
Mm-hmm.
It is certainly, as Father Crean and Dr. Phimister say, connatural with Christianity and Christendom, but then so is the Roman system. But that doesn't make it the perfection of reason. It is a system of law, and it will have flaws like any system of law. So, but Coke, because he was a Puritan, and because he wanted to use the common as a way of establishing in the kingdom his form of Christianity versus the king's form of Christianity, used the common law, and so built it up into this great thing, this great icon, which he called the perfection of human reason. And of course then wrote his Institutes, which were treated as a kind of second Bible for lawyers. But he inevitably fell into conflict with the Court of Chancery, and with people like, mainly with King James I. And that was bound to head into a conflict. Now, it's not entirely true, but there was a sense in which the Court of Chancery tended to be associated with the king, and the common law courts tended to be associated with Parliament. But that is a grotesque exaggeration. But it has to be said that there are a lot of common lawyers who are Puritans. On top of that, you've got persecution going on in the time of King James I. Catholics, whilst they weren't as heavily persecuted as they were under Queen Elizabeth I, who was a shocking persecutor of minority religious views, not just Catholic, but also Puritan, and anyone outside the Church of England. I read somewhere, I don't know if this is true, that she had 800 people executed for religion in the first year of her reign alone. Well, that is more than twice as many as the Spanish Inquisition executed over its entire 350-year history. But which of the two is held up as the token of totalitarian awfulness? Spanish Inquisition. It pales into insignificance next to the totalitarianism of Queen Elizabeth I. But no, Queen Elizabeth I is presented as Gloriana, the great builder of the new empire and kingdom of the British. No, sorry.
Bloody Bess.
Simply not the case. However, slightly less persecution under King James I, but it was still going on, whether it was Parliament doing it or the king. And the king himself sat in and listened to numerous trials of seminary priests and Jesuits. We don't get a full picture of what he thought of them, but I'm reasonably confident that one of the things he thought was, whilst I may not be very happy with these Catholics, I'm not at all happy with these Puritans either. They're going to have my head off soon. And as he put it himself, in opposing the move of the Puritans to abolish episcopacy, no bishop, no king. And of course, he was right. Along comes the Civil War with his son, King Charles I, who does indeed get his head chopped off by the Puritans. And no sooner has his head been chopped off, or even earlier, when Archbishop Laud's head is chopped off, no bishop, no king. And the Puritans did not have bishops. And indeed, the English Puritans who were finally successful, the so-called Congregationalists or Independents under Oliver Cromwell, were far more radical than the Presbyterians. The Presbyterians remained loyal to the king, with the exception of the extreme Covenanters, throughout the period of the Civil War, whereas the Congregationalists cut his head off. The Congregationalists were so extreme, so radical, They believed that each congregation should decide its own doctrine. And the result of that was that, because the Puritans who went to America brought that form of Christianity to America, the result was that on one particular period in the history of American Christianity in New England, a whole series of churches decided to have a vote on whether they believed in the Holy Trinity. Half of them decided they didn't, and the other half decided they did. And those who were in the majority stayed, the rest crossed over the green and set up an opposing church on the other side, which is why when you go across New England to this day, you will find there's one church on one side and one church on the other side of the village green. One of them is Trinitarian and the other one is Unitarian. So that's what happened to Cromwell's religion, and would have happened here, except that, of course, he was eventually defeated. And Anglicanism, mainstream Anglicanism, was brought back with Charles II and the Earl of Albemarle and the Coldstream Guards. And with that, you then had a restoration of the common law as it had hitherto been. Because during the interregnum, during the period of the Commonwealth, which, by the way, let us not forget, was a unitary state over the whole of England, Wales, Scotland, and Ireland. So, Scottish Republicans, Irish Republicans, Welsh Republicans, if they exist, had better remind themselves that Cromwell was no favourer of nationalism, Welsh, Irish, or Scottish. He wanted a unitary state. And that what had existed before then were the three kingdoms, England, Scotland, Ireland, each ruling themselves under one king. So who was the devolutionist? Who is the believer in nationalism? Ironically, from the point of view of a Republican, the Royalists, not the Republicans. And so it proved, but the English, with their genius for compromise, found a halfway house. They restored the common law. I mean, during the period of the interregnum, common law was still there, and you still had courts. And in theory, they still operated as they had done before, but were inevitably overshadowed by a Puritan Parliament, brought back again in its old form, but with certain changes being forced upon the king, which he didn't like. For example, the abolition of feudal tenure. Let me just remind myself. 1662, I think it was. Yes, the Tenures Act of 1662, chapter 19 of year 14 and 15 of Charles II, that abolished feudal obligations of those holding those feudal tenures other than by soakage. You remember I mentioned free and common soakage, such as by knight's fee. It standardized most feudal tenancies of the aristocracy and the gentry, and converted most of their tenures into ones which demanded nil or negligible obligations to the crown other than payment, if indeed you were paying a fee. By the way, the original feudal system of land tenure and land law was again resurrected by an American economist whose name will come to me in a moment, and is now represented by a movement in America, which has been put into place in certain parts of America successfully and in other parts of the world, called the single land tax movement. Why that? Because that's what they had in the Middle Ages in the feudal system. If you weren't giving services, judicial, military, administrative, or manual labor, you paid a fee. That fee was a rent, or if you like, a tax, a single land tax or rent, and it was on the value of the land unimproved. If you built on the land, the tax or rent did not go up. And this system was resurrected in the economic theories of Henry George, who was who several times, I think, or at least twice, stood for president of the United States and was elected to various offices, I think, in New York State. And a lot of people in the early 20th century, including Winston Churchill, favored the single land tax system. But it got nowhere because of vested interests. Because in the single land tax system, if you own land in Mayfair, you pay a much higher single land tax than you do if you're in Wales or in, I don't know, Black Country or somewhere. The more developed it is, the higher the rateable value, and you pay tax based on the rateable value. And that's how it was under the feudal system. So if you like, it's a kind of modernized version of the feudal system. And what some mathematicians have done is to calculate that the tax raised by that system, based upon rateable value, would be enough to fund the entire government without income tax, VAT, corporation tax, inheritance tax, or capital gains tax. Can you imagine what effect that would have on enterprise if all of those taxes disappeared except the single land tax?
Mm.
Knowing that all your profits come back to you, all your hard work comes back to you, would be a massive incentive for economic development and growth in a country, as it was in the feudal times. So it just goes to show you that people haven't thought through their criticisms of the economic, land, and legal system that subsisted before the Reformation. By the time of Charles II, Tenures Act is the kiss of death for the final kiss of death for those feudal systems and obligations, and everybody thereafter holds in free and common soakage and no longer has to pay anything other than a fairly minimal single land tax, which, by the way, continues to this day as ground rent. You heard the expression ground rent?
Yes.
Everybody pays a small sum, tiny sum, usually, £20 a year in ground rent. That's all that's left of the single land tax from the Middle Ages that was paid under free and common soakage by Franklins, or various other names that were given to them. But you still have now a certain element of contest between the Chancery courts and the common law courts, and but it's calmed down. Whereas in the early 17th century, there was a battle as to whether writs could actually a writ from the Chancellor's Court could remove a case from the common law court to the Chancery Court. The common law judges resisted it. Said no, the common law is, people like Cook would say, no, the common law is the perfection of reason. You don't need to go to the Chancellor's Court. But it was also part of their battle against the king. That was partly resolved. But then, of course, what happened next was you got King James II on the throne, Catholic king. They all the people who've enriched themselves from the Reformation are now running scared that King James II, as a Catholic king, might turn the clock back, might resurrect the monasteries, might make them disgorge their ill-gotten gains, even though he many times said, I'm not going to do that. I can't do that after 200 years. They still didn't believe him. And whilst modern historians say, oh no, his government was arbitrary and he was trying to impose Catholicism on the country, absolute rubbish. He wasn't doing anything of the sort. And he was imposed into leaving his own Catholic officers in the army. No, he just wasn't stopping them, which is what happened under Protestantism and under the Test and Corporation Acts. You no longer had the Test and Corporation Acts, which required you to call the Pope Antichrist and to take the Anglican sacrament, or else you couldn't hold office.
Yep.
He got rid of that. Well, they didn't like that. And then, worse, shocking by the standards of the wealthy upper classes, he produced the Declarations of Indulgence, the latter of which made it everybody was free to practice their own religion, provided it did not interfere with or try to undermine the state. Everybody, Quakers, every Congregationalist, you name it, they all were now free to practice their religion. And although it doesn't expressly say it, interpreting the Declaration, if you read it, must also have included Jews and Muslims. And this is the guy who's regarded as arbitrary, backward, totalitarian. His declaration is a document that would stand in 2024 as being enlightened, because it offers freedom of religion to all religions, as long as they don't conspire against the state, which, of course, some of them were certainly going to do. And for that, the supposedly lovers of liberty, who were the enriched aristocracy, threw him off the throne. And in 1988, the then Lord Chancellor, Lord Hailsham, Bitten Hogg, tried to get the government to celebrate a tercentenary of the Revolution of 1688, which threw King James II off the throne, on the basis that it was a celebration of our liberties. No, it wasn't. It was a crushing of liberty. The liberty to practice your own faith was crushed in the 1688 rebellion, and Anglicanism was made the compulsory religion of the entire country. England, that is, and in Scotland, Presbyterianism, and in Ireland, Anglicanism, even though everybody knew that 90% of Irishmen were Catholic. And in Wales, even though there were lots of dissenting sects in Wales. It was just an imposition of the Anglican. Now, some people said, oh, well, what the heck? Because within the Anglican Church, you could hold just about any religious view you liked, and nobody would stop you. So, for example, you have people like John Locke. It's almost certain that he was a Unitarian, but he's a communicating member of the Church of England. So anything went. So, from the point of view of religion, they said, well, this is liberty because although we're all Anglicans, we can believe what we like. But then Anglican divines said, no, you can't. You have to believe the doctrines of the Church of England. And even more so, the non-jurors who had been ousted by the post-James II regime, the Williamite regime, because they continued to recognize King James II as king, because that was what the doctrines of the Church of England taught, and William was a usurper. And even though those very same non-jurors a year or two earlier had refused to read the Declaration because they themselves were not in favor of toleration of all religions, they only wanted Anglicanism, they at the same time, consistent with their own principles, said, yes, but you can't throw the king out, however much you dislike him. That would be contrary to Anglican doctrine. So they were thrown out. And the non-juring succession carried on until I think as late as 1868. The last non-juror died, and they kept going across to Saint-Germain-en-Laye, to King James II in exile, to get all their episcopal appointments approved. They, if you like, were a parallel Church of England. Now, isn't that a modern idea? Haven't we now got something similar here? People who dissent from the current regime of the Church of England are setting up alternative churches of England all in various parts of the country. They don't have a great deal of success, but there they are. So you then now have the 1688 Constitution, and it is another revolution on top of the Protestant Reformation and on top of the Cromwellite Revolution, which also has a very significant impact on the law, on the common law and on the courts of equity, but chiefly on the law as a whole, because for the first time, Parliament is put above the king. Parliament chooses the king. Parliament gets rid of the previous king, and therefore Parliament is above the king. And so it is. And that was the compact which was reached between William III and Parliament. And he said to them, look, I need money if I'm going to come over and govern. And they said, right, the Bank of England, which was a private institution then, go to the Bank of England. They will lend you 8 million. They went to the Bank of England and said, look, I need money. Through his messengers, obviously he's still back in Holland then. And they said, yes, we'll give you 8 million, a lot of money in those days, provided you allow us to lend 8 million to the economy. Oh, yes, of course, he said, not realizing the hugely inflationary effect that would have. It'd be like injecting I don't know, 80 trillion into
Mm.
the economy now. Yeah, hugely inflationary. Right. So once that was agreed, he was invited over, and all the bigwigs, who of course were still in the army, who were not Catholics or not pro the king, deserted King James II, led by the Earl of Sunderland and John Churchill, later Duke of Marlborough.
Mm.
They were going to capture the king on Salisbury Plain, but he had a nosebleed and didn't turn up for their rendezvous. So they said, right, never mind, and took most of the army over to William's side, after which it was a foregone conclusion. King James II had to leave, and William and Mary took over. Then in 1701, when Queen Anne died, she was still a steward. I mean, obviously, William and Mary were both stewards. Mary was, in fact, the daughter of King James II. She never liked the fact that she had been made queen in her father's place.
Mm.
But it was, it was forced on her. You then had Queen Anne, poor woman, 17 pregnancies and not a single one survived.
Mm.
She was the last steward. And she, towards the end of her life, especially after she fell out with Sarah Churchill and John Churchill, she began to think that she was being punished by God because she had usurped the position of her brother, King James III, or who should have been King James III and eighth of Scotland. By the way, the Scots, they I think I'm right in saying, they never accepted although they introduced the Act of I forget the name of the act, equivalent acts as the 1688 legislation. They never accepted the removal of the Stuart monarchy in 1701.
Mm.
I think it's called, I forget what the act is called in Scotland, not the Act of Settlement. It's got a different name. But they didn't accept the removal of the Stuart kings, but they accepted it in that 5-6 years later, after truckloads of wagon loads of English gold went north to bribe all the Scottish parliamentarians, they accepted the Act of Union.
Mm.
But the reason why the Act of Union was put forward was because the Scots would not accept anything other than the Stuart monarchy, the Stuart dynasty, who of course were originally Scots.
Mm.
So, but Parliament, the English Parliament, jumped over all the successors of Queen Anne until they found a Protestant. And numbers vary, but I think there's a list somewhere. Something like 55 princes were overlooked, either because they were a woman or because they were Catholic. 55, of whom 44 were Catholic, until they arrived at Prince George of Hanover. And that is how the Hanoverians became king. King George the First came over here with a mistress on each arm, having locked his wife up in a castle back in Hanover. Arrived at Tilbury Docks, was booed by the London crowd. One of his mistresses stuck her head out of the window and called out in not very good English, "My people, we have come for your goods." And one wag in the crowd shouted, "Aye, and our chattels too."
Mm.
And there were something like riots in 20 different countries around cities around the country against the coronation of King George I. King George II was even less attractive a character than George I, and it was during his reign that the Jacobite uprisings, which were supported not only in Scotland but also in many people in London, like Dr. Johnson, by the Welsh, and by many people in the north of England. And if Bonnie Prince Charlie had not turned back from Derby in 1745, he might well have succeeded, but he didn't. And so the Hanoverians were then secured, and after him, King George III, who was the grandson of King George II, was a very different sort of person and was genuinely English and loved England and loved things English. And although he was mistrustful of the Catholic Church, he was more of a Tory than a Whig. The Whigs were those who had brought in the Revolution of 1688, and he didn't really trust them.
Mm.
And so during that period, although the government is very oppressive. The courts developed, and the common law and the equity courts developed independently of the unsatisfactory nature of the government. The maxims of equity became pretty much as rigid as the common law. So you're back to square one in that you haven't got anybody with the flexibility of the natural law or the Bible to say this is unconscionable because it's against the natural law. You've only got it's unconscionable, yes, because it doesn't conform to the maxims of equity. But the maxims of equity are not coterminous with the natural law. They're jolly useful, but they are not the full sum of the natural law. And so and by then, by the way, the courts of equity actually, before the beginning of the Civil War, the courts of equity had won the battle between them and the courts of common law courts. In other words, if you didn't get justice in the common law courts, you could get a writ to take you across to the Chancellor's Court, provided it was an issue of conscience dictated by the maxims of equity. Otherwise, the Chancery Court would say, no, sorry. So that's the position you've got in the 18th century, but the maxims of equity are nothing like sufficient to plug the gap in all areas where injustice is created. They're jolly useful, but they're not the sum total of the natural law. And so that created problems which continue to this day and which can only really be resolved, short of going back to the system before the Protestant Reformation, by statute. In other words, by Parliament being persuaded, this is unfair, we need a law to rectify it, or by the conscience of judges who can see it's unfair and so mould the law to give a just result. But you've got to be careful with that, because if that goes too far, you get what's called judicial activism. And judicial activism is judges usurping the role of Parliament, which is to say, judges making new law, when that's the job of Parliament. And in a democracy, an elected Parliament democratically. So if a judge does that too often, quite rightly, he gets criticised, not only because it's contrary to our Constitution, but because nobody voted for him, whereas they voted for the parliamentarians. And people will say, sorry, Judge, you can't do that. We are the elected Parliament. Now, there's nothing to stop Parliament overruling the judge, but Parliament nowadays is so fraught, so busy, so churning out law after law after law in a way that is quite ridiculous, and is so influenced by polls, public opinion, the media, that unless the piece of injustice that they're supposed to be rectifying is in the media spotlight, they're not interested. And that means that there's going to be, and there is currently, loads and loads and loads of injustices that are not rectified if the courts and judges won't rectify them. Now, the 19th century was a period of the most, in modern times, beneficial development of the common law and the Chancery and the Chancery courts, because there was a revival of Christianity, largely caused by evangelicalism, by people like John Wesley and Spurgeon and others who, and also, of course, the Oxford movement, which was a continuation of the old non-jurors. So you had high and low in the Church of England, both of them interested in truth, morality, and justice, but from different perspectives. The result was very beneficial for the development of English law. Cardinal Newman had a very high opinion of lawyers and barristers, because he could see how the evangelical revival and later the Oxford movement had influenced the conscience of judges and lawyers. And so throughout the 19th century, you get probably our best judges ever since Reformation. Not all of them, of course, In the early 19th century, you had people like Lord Eldon, the then Lord Chancellor, who would sit on the case for 3 years, and was notorious for his shocking delays. But that was before the evangelical revival had really taken off. At the same time, you're getting throughout the British Empire, because of the revival of Christianity, attempts to abolish slavery altogether. The Royal Navy goes around the world abolishing the slave trade. You get rid of horrible practices such as sati and thuggee in India, where widows are burnt on their husband's funeral pyre. The cult of the goddess Kali, who believed that it was beneficial to murder a large number of people. Their blood would then somehow benefit the nation. And various other repellent practices throughout the British Empire were stamped out by the British because of the revival of evangelical Christianity. And it had the same effect in Britain. But it had begun in the 18th century. And you started to get some judges who were, for example, when you had 200 capital offences at the time of the Napoleonic Wars and the French Revolution, because at that time, rather like now, people were persuaded that stiffer penalties would deter crime. Doesn't work. What deters crime is the prospect of being caught. And that eventually came with Sir Robert Peel introducing a professional police force. Sorry, I've got this beastly cold. But at the same time, you did have people in the 18th century who were beginning to say, on the basis of either evangelical Christianity or the non-jurors high churchmen, slavery is wrong, we must get rid of it. Whereas during the period of the revolt of the rich didn't care about that. They just wanted more money. And that still continued in the 18th century. If we have slaves, we'll have more money, let's have slaves. Having said that, it's completely false, the idea that European slave traders went across to Africa and chased people down, stuck them in cages and put them on ships. No. By and large, there were slave markets, and they would go to the slave markets of Liberia and buy their slaves. These slaves had already been enslaved by fellow Africans or by Arab traders. However, the apogee of this is in the Court of King's Bench by a very famous judge, Lord Mansfield, who was the son of the Earl of Stormont. He was a Murray, therefore Scottish, and the Murrays were the largest clan to support the Jacobite Rising. A whole brigade. They were called the Brigade of the Athol Men because their leader was the Duke of Athol. And one of the subsidiary titles was the Earl of Stormont. And he was a staunch Jacobite, as was his eldest son. But what a lot of the aristocracy did in those days is they said, right, one of you can go out, the other one must be completely separated from the uprising, so that if we lose, everything will go to you and we won't lose the family fortune. And Lord Mansfield was one of those. And so he was sent down to England to be educated. He went to Eton, read for the bar, the English bar, not the Scottish bar. I think Lincoln's Inn. And eventually he became Lord Chief Justice of the Court of King's Bench. I think it was King's Bench, it might have been Common Pleas. And he is famous for two things. One, for the beginnings of the law mercantile, commercial law in this country. Commercial law now straddles equity and the law. So even now, we have a lot of commercial cases will be brought in the Chancery Division, but there is a separate commercial court, which is a branch of the King's Bench Division, which is a common law court. But the commercial court and the Chancery Division both sit in the same building, the Rolls Building just north or just to the east of the Royal Courts of Justice, a very modern building. And he developed the mercantile law as the beginnings of what we now recognize as modern mercantile commercial law. But he also famously gave a decision in the case of Somerset against Stuart, 1772, in which he declared slavery was contrary to the English common law, or at least the slave trade. Depends how you interpret his words as to whether he completely ruled out slavery from the common law. That sent the absolute chickens rustling in all directions in the American colonies, because of course their economy depended upon slavery, and a pretty crude form of slavery, not the heiress of the Old Testament, not indentured servitude, not the slavery of the Roman Empire, which included at least one doctor of the church. Well, at least one doctor of the church was a servus, and the Latin word servus really means indentured servant, not slave, but real slavery, as in we own you, you do what we say, and we can do what we like with you. And so a lot of people say, and in particular, if you've read Liberty, the God That Failed by Chris Ferrara, his primary thesis is that, one of his primary theses is that Lord Chief Justice Mansfield's decision in the case of Somerset and Stuart was directly what led to the American Revolution, which of course occurred only 4 years later. Because the Americans thought, and because English jurisprudence, guided by English judges in London, spreads throughout the British Empire and has, through the doctrine of precedent, a binding effect, they thought some of our judges, maybe all of them, are going to say that what Lord Mansfield has said means slavery is illegal in common law countries like America. We've got to get rid of this guy and this king and this government. So it was nothing to do with the Boston Tea Party. Boston Tea Party was throwing the tea overboard because it was cheaper, not because it was more expensive. And because it was cheaper, it meant that these imports were taking profits away from rich American tea merchants. Nothing to do with except in the sense that action was taken against British traders. But beyond that, it has no connection with the American Revolution. What really did it was, hey, he's going to take our slaves away. So that was Lord Mansfield, and he subsequently was raised to the peerage himself as the Earl of Mansfield. And I might add that there then were two Earls of Mansfield. They now have conjoined again, and the present Earl of Mansfield lives in Scone Palace in Scotland, which was the original royal palace of Scotland. And his wife, and I think most of his children, are Catholics, interestingly. So already in the late 18th century, you're beginning to see a wonderful improvement in the development of the common law and the equity courts as well, which goes on to develop yet further throughout the 19th century. And that is the period in the 19th century when the English common law and the English law, judge-made law generally, including the equity courts, gains its worldwide reputation and is spread throughout the world through the British Empire. So that all those countries that were once part of the British Empire now still have the common law, including America, Canada, Australia, New Zealand, India, and the Caribbean. And as we'll see in just a moment, they are now reckoned to be, and I would say this is largely down to that 19th century development, the best and fairest judicial system in the world, by quite a long way. But don't think that we can't wreck it, because we could. The mere fact that we are living on the capital of the past does not mean that we aren't going to waste it. And that brings me really up to the present day, which I'll get onto. But having spoken for a considerably long time, you might want to just interject with some other things.
Well, I think there's so much there, and it really contextualizes some of the concepts that Dr. Phimister and Father Crean outline in their book. But I think that the points you've raised in the general principle that law accumulates like this sort of topsoil of a forest, and that common law rests on the doctrine of stare decisis. This is something that can be traced from the very beginning, when courts, customs, past decisions would take precedence over royal decrees, even in Anglo-Saxon times, when the Anglo-Saxon codes were summaries of custom, which the king then declared as law. And this is a point that Phimister and Crean emphasize when they discuss Emperor Justinian's codification of the law in his Institutes and Digest, where he made up for the devastation of the fall of the Western Roman Empire, the loss of the great libraries, which enabled the former precedent-based multivalent system with its sources in the 12 tables, the decrees of the Senate, the Assembly, various plebiscites, and covered this absence, as it were, with the famous Lex Regia, by which, quote, it's recorded in the Digest, by an ancient law, the Legge Antiqua, which was once called Royal Regia, all the authority and all the power of the Roman people were transferred to the power of the emperor, end quote. And so they argued this sort of seeded a temptation for statism in the civilian system, which when Justinian's law was rediscovered in about 1070, enthused the jurists concentrated in Bologna, who favored the Roman law over the Christian customary law, the older Christianized Roman law, so as to give more power to the prince they served. And this is something that princes like Philip IV of France, Philip le Bel, would make use of, and gave rise to the Dominium Regale, which grow over the following centuries.
Yes, that's exactly right. And in fact, Dominium Regale and the Lex Regia, developed particularly during the Renaissance period as a result of reading political and legal texts that had recently been discovered from the ancient world, and gave a lot of people like Machiavelli, the idea that not enough power had been given to the prince. Too much power was devolved, as in the Middle Ages. This was, although Machiavelli was a Catholic, and all of those who followed his method were Catholic. Actually, the idea of a despot who has all the power is a pagan idea. The Christian idea is to devolve, distribute, and subsidiarize power. And as you rightly say, although it's not easy to find clear, specific precedents, it seems that the common law could act as a check even on royal power. Now, yes, they were the judges were the king's judges, and much is made during the English Civil War of the fact that judges were appointed durante bene placete nostro, during our good pleasure. In other words, the king, they're implying that the king could sack a judge by clicking his fingers. It's not true. He couldn't. And therefore it ought to be replaced by quam diu se bene gesserint, so long as he holds himself upright and just. Well, who's going to determine that? The answer is not the king. Parliament's going to determine that, which means the Minister of Justice, which means either the Lord Chancellor or the Attorney General. Well, okay, fine. All you've done is transfer the power of selecting and sacking judges from the king to the Attorney General. How's that progress? The answer is, of course, it isn't progress. Nowadays, the position is actually quite good. You cannot sack a High Court judge or a Court of Appeal judge or a Supreme Court judge except by an address of both houses of Parliament. In other words, both houses of Parliament have got to vote the judge out. And that hasn't happened since 1812, I think, in Ireland, when Jonah Barrington, who was a High Court judge in Ireland, was, by an address of both Houses of Parliament, removed for gun running to the rebels.
Hmm.
Well, if you have a judge who's running guns to rebels, unsurprisingly, Parliament is likely to vote them both out. But if you have someone who's otherwise a very good judge, like his name's gone out of my head, the judge who said he didn't know who Gaza was, I don't know if you remember that, you're perhaps too young to remember. He was a very good property judge, a High Court judge in the Chancery Division, and he also famously thought he was kicking a member of the press for taking too many photographs of him, and turned out that he kicked a taxi driver by mistake. He was not. He didn't retire for these reasons. Mr. Justice Harman, Jeremiah Harman, a relation of the Labour Minister Harriet Harman, but because he had lost his notes from a case he had been hearing, and the whole case had to be heard all over again at huge expense to the litigants. Well, there wasn't an address of both Houses of Parliament. The senior presiding judge in his division and probably the Lord Chancellor said, Jeremiah, old boy, I think it's time you went. And he very sensibly said, yes, I shall go and take my pension with me.
Mm-hmm.
So that's now how High Court judges tend to be removed. But that's basically a better system than the Attorney General or the King. But who appoints them? That's I think, an important issue. And I'll come on to that in just a moment, because the way the common law is heading, and the law generally, is important. It's troubling. But I just want to touch on one thing. In your list of things, you've got the jury and the concept of a trust. A jury can be dealt with very, very straightforwardly. Juries exist in a lot of legal systems, not something common to the common law. It existed in Roman law as well, but it became famously associated with English common law, particularly in the 19th century, when you had great orators who addressed juries. Some of our great judges, like Norman Birkhead, who is actually a bit more the 20th century. Some very great judges, lawyers who made the jury system very much a central part of the English legal system, and not just the 19th century, but also the 18th and the 17th and the 16th. So that when the American Revolution took place, it became, along with a number of other fundamental parts of English common law system, keystones of the American Constitution. Right to trial by jury is a constitutional right, and a whole lot of other things. Right to silence, freedom of speech, and so on. These all come from the English common law tradition. And some would say, because it's a written constitution, therefore can only be changed by a referendum, not by a vote of Parliament, the Americans have a legal system has, in some respects, preserved the English common law better than we have, and better than some other common law countries. But there are pluses and minuses on that. The concept of jury, therefore, became absolutely central. Famously, you had Lord Russell of Killone, Charlie Russell. In the 19th century, he was the barrister in the Times, the inquiry into the letters written to the Times by members of the Anti-Parnell party, in other words, what we nowadays call the Protestant Orangemen, who were trying to link Charles Parnell, who himself was a Protestant, not a Catholic, but who was a great campaigner for Irish nationalism, with the Phoenix Park murders, because a group of Irish terrorists murdered the two most senior members of the British government in Ireland, Lord Frederick Cavendish, and I forget who the other one was, in Phoenix Park. It was an outrageous murder, in such a central position. And he cross-examined the chap who supposedly had written the letters, but who denied it. And it is probably one of the most famous cross-examinations in English legal history. He got the chap to write down the word hesitancy on a sheet of paper, together with several other words, so as not to make him aware of what he was getting at. And this chap spelt the word hesitancy wrong, with an E instead of an A. Russell took it, shoved it under his prie-dieu, then went on to cross-examine the fellow and cross-examined him so successfully that he was just completely not credible at the end of the cross-examination. And then the coup de grace, when addressing the court at the end, was, these are the letters. This is what he's written. Notice the spelling of the word hesitancy, identical. So the Protestant Orangemen were effectively completely worsted. Russell himself was an Ulster Catholic. I should say that the chappie he cross-examined, whose name was Piggott, was then pursued by the police for perjury and was finally tracked down somewhere in Spain in a hotel. And when he heard that the police were there, went upstairs and sadly shot himself. That must have made Charlie Russell feel a bit distressed, but it shows you the power of the English common law courts when at their very height of their prestige in the 19th century. Russell went on to be promoted to a judge, I think, and he was eventually made, believe it or not, Lord Chief Justice of England. So those people who say that, in the 19th century, all the English hated the Irish and Catholics and were bigoted and prejudiced against them, well, maybe not so much, because Charlie Russell began life as an Ulster Catholic and as a solicitor, then became a barrister, called to the Irish bar, called to the English bar, and ended up as an Ulster Catholic, as Lord Chief Justice of England. So maybe the prejudice wasn't quite as bad as people think. Anyway, that's a different story. But the concept of a trust, just touch on that very briefly, is something that is also, it's a creature of equity, not the common law. But I think we've already made it clear that when we're talking about the common law, we're also talking about the courts of equity. English law generally is also a concept that comes from Roman law and exists and continues to exist in both Scotland and Liechtenstein, but does not exist in the Code Napoleon. And that creates all sorts of problems for the Code Napoleon civilian courts in the continent of Europe. The prestige of the English courts, so high in the 19th century, is still high. So high that most people will not go to anywhere near the continental courts, except perhaps possibly the German courts, but will want to go to a common law court. And why not go to the source? They go to the English common law, and that's why we have so much litigation in this country, because people trust the system, they trust the common law, and they trust our judges. How long that will last, I don't know. I hope for a good long time in the future, but it depends on us keeping our standards up. Now, the concept of a trust began in a religious context, because religious orders, many of them, were not allowed, the individuals are not allowed to own property in order to fulfill their vow of poverty to the full. And indeed, the early Franciscans under St. Francis would not even allow the community to own property. They appointed other people to own the property on their behalf. This developed into the concept known as the use, which meant that X owns A for the use of Y. And that's a trust. If you own property for the benefit of somebody else, you are a trustee. And that immediately imposes upon you a whole lot of obligations of good faith, which are called fiduciary obligations, obligations of good faith. And they are not common law obligations. They're not determined by precedent and judges. They're determined by the courts of equity, the courts of conscience. It is of a creature of equity and of conscience that you will use this property for the benefit of the beneficiary. And if you don't, conscience says you have breached your duty of good faith. It's a classic central part of the whole of the law of equity. Now, Henry VIII, who wanted to get to steal all the property of religious orders, he passed a statute through Parliament that executed all uses, so that the beneficiary owned the whole of property, absolutely.
Mm.
Because we don't have religious orders anymore. So we don't need to hold Franciscan property on behalf of the Franciscan friars. The friars don't exist anymore. The people who were friars, they can now own the property themselves in their own name. So got rid of the whole law of uses, now called the law of trust, in one foul swoop. However, it was such a useful device, not only for religious orders, but commercially, and in proprietary or property law, that it came back in again. And this time it was devised by Chancery lawyers who devised what was called a use upon the use. A shall hold the property upon the use of and for the use of Y. So it was a use upon the use. The first use was automatically executed by the statute of uses, but the second use continued. And thus was developed the law of trust and continues to this day. Now, finally, if I may, what's the position of the law now, the common law and the courts of equity? Well, we have a problem, which is a familiar one to those who are students of the early days of the law of equity, when it was said by common lawyers, what are the rules of equity? Answer, they depend upon the length of the chancellor's foot. In other words, it's arbitrary. And this is a system that was brought in with the French Revolution. It is an entirely new kind of law, which is completely different from the common law, and that is the law based upon human rights, or rights-based law. And one of the primary features of the common law, and indeed the law of equity to a large extent, is it is a duty-based law. And all the statutes up until modern times would be predicated upon the fact that the common law is a duty-based law. So if you wanted to create certain statutory duties, you would name them and set them out. You have a statutory duty to do this, you have a statutory duty to do that, and this, and that, and this. And if you don't do them, these are the penalties. You can be sued. Or if it's criminal, you can be fined, and so on. And that reflects the duty-based nature of the common law. And it's much easier for a judge to administer that kind of law, because all he's got to do is listen to the evidence and decide, was this statute applicable? Yes. And if it was this duty applicable? And if it was, did you or didn't you break it? Did you do the thing you were obliged to do or didn't you? No, we didn't. Well, then I'm afraid you're in breach of your statutory duty. And therefore, I will find that in favour of the claimant. And I now want to know what loss it has caused. Right, well, then you will pay that loss plus interest plus costs. They're relatively straightforward. But rights-based law is a very different thing. Because what happens with rights-based law, it's not quite the same as, but has certain similarities with the early days of the Maxims of equity, is that there are certain rights, like the Maxims of equity, set out, and they're set out in a document which looks suspiciously like a code, whether it's the UN Declaration of Human Rights or the European Convention on Human Rights and Fundamental Freedoms. It's effectively a kind of code. And it says you have a right to this, you have a right to that, you've got a right to life, you've got a right to be free from torture, you've got a right to free speech, a right to free assembly, you've got a right to a fair trial, a right to be free from discrimination, and so on and so on. Now, they're not duties, they're rights. So when you go to court and insist on this right, how is a judge going to determine whether your right has been infringed or not? Well, it's not so difficult if it's just, has my right been infringed? Although it's not entirely easy. On what basis do you determine whether your right has been infringed or not? But what happens if you've got two conflicting rights? The right to religious freedom, the right to freedom of speech, the right to have your religion protected, the right to have your free speech protected. I want to say Jesus Christ was homosexual. I want him to be stopped because that offends my religious beliefs. Well, who wins? That's just one example. Or I have a right to be free from torture. Yes, but you're a terrorist and you're going to blow up that that room full of school children. There has to be a limit to this right. Of course, each of these rights set out in the European Convention does have limits, but they're not exhaustive by any means. So the judge has got to make that determination himself. The bottom line is rights-based law is not really law because it's not based upon precedent or statute. Well, that's partly based on statute. It's based upon the length of the judge's own foot. Do I think this right should trump this right or the other way around? Now, it is true that there are, of course, precedents where a judge decided this in one case and another judge decided this in another case. But the whole point about human rights law is that the judge has got to be able to look at it independently, afresh, and say, look, I know that happened in this case and that case, but I think in this case it will be a breach of his right if I didn't, if I didn't find in his favour. So it's not really based upon law. It's based upon the judge's own discretion, the judge's own conscience. In short, the length of the Chancellor's foot. And that is a very serious problem that we are now facing in all of our courts, from the lower to the higher, where issues of human rights are coming in. Now, not only that, but you've also got a political agenda here, because it is very much an agenda of the political left to infiltrate human rights law, rights-based law, into the common law system in order, effectively, they wouldn't put it this way, to undermine it, to white ant it, and to convert it into a rights-based law system.
Mm-hmm.
And then to persuade judges and legislators that the rights that should be upheld are rights that are contained in various left-wing manifestos. So, for example, if you have a right not to be discriminated against on the basis of your race, that only applies to particular types and particular races. But other races, perhaps the majority, they can't be discriminated against. Why not? Well, because they're the majority. Who says? Because some judge says it.
Mm-hmm.
And why does the judge say it? Well, because some civil servant somewhere has written, or perhaps another judge, has written some guidance to guide judges when they are applying rights-based law. And the guidance says, if you're dealing with racial discrimination against the majority population, they can't really be discriminated against because they're the majority. It doesn't quite go that far, but you see the point I'm making.
Mm-hmm.
Or, well, we don't want to have equality of outcomes. We accept that, but we should lean in that way in order to redress the balance. One judge says that's a good idea, another judge says no, it isn't. Or the guidance says it's a good idea and we should follow the guidance. But why should we follow the guidance? The guidance was written by somebody who's not elected, is not a member of parliament, and may not even be a judge.
Mm-hmm.
And why should the judge follow the guidance? You see? So it is actually a bit of a Trojan horse in a common law system. Undermines the simplicity and effectiveness of the common law system, which is a duty-based system, by introducing the arbitrary concept of rights-based law, which, however much the common lawyers in the 17th century may have criticised the Court of Chancery for being arbitrary because of its maxims of equity, it's far more arbitrary under a rights-based system than it is in the courts of equity, because at least in the courts of equity, you had a system of precedents that told you what it meant by the words equity is equality, or those who come to equity must come with clean hands, or whatever the other maxim that you wish to deal with. And also the maxims of equity deal only with those issues that come before a court of equity. The rights-based law is across the board in all courts and must be applied in all courts. Why? Because Parliament passed a statute called the Human Rights Act of 1998 that says it will be so. And statute, not the natural law, not the Bible, and not the church, is now the supreme authority in the state. And as we were taught at bar school, something that would never have been taught in the Middle Ages. Parliament can make it illegal for a Frenchman to smoke in the streets of Paris, even though France is not part of our country or jurisdiction. So that if Parliament was stupid enough to do that, a Frenchman coming to England for a holiday could be arrested for smoking in the streets of Paris. I saw him. I've got 2 witnesses, my lord. He was smoking in the streets of Paris. And that is to emphasize to law students how supreme the power of Parliament is and the importance of parliamentary sovereignty. But Parliament should not be sovereign. What should be sovereign is the natural law and the Bible and truth, in short. In a Christian state, even in a non-Christian state, there's something has got to be higher than Parliament. Even if it's the Quran or the Bhagavad Gita, something has got to be higher than an assembly of human beings deciding what the law is. And if we have any doubt about that, we should ask ourselves, well, did you agree with the law that made homosexual acts illegal from 1866, I think it was, onwards, or 1861? Did you agree with the law that made abortion illegal from 1861 onwards? It was already illegal before then. And a lot of liberals will say, no, that was wrong. I see. But if you were a judge, you would have enforced that, would you? Oh, and then you've got them. And if there's any doubt about that, you can go onto the internet and watch an American judicial candidate being interviewed by a Senate Judiciary Committee. And one of the senators, very clever fellow called Senator Kennedy, not RFK, but the other Kennedy, cross-examined her and said, well, you say that you would support the law. Absolutely. You've told us on oath that you would always uphold the law. Is that right? Yes. So supposing you were a judge in the 1870s, yes, there would have then have been the decision of Dred Scott in the Supreme Court determining that Mr. Dred Scott did not have constitutional and human rights as a federal citizen. He did have them as a state citizen, but not federal. Would you have upheld that law? And of course, she's completely stuck because she's declared herself to be a liberal who's opposed to slavery and wants to be elected on the basis that it ought to be discrimination in positive discrimination in favor of black people because of the past history of slavery. But at the same time, she said, I'm going to uphold the law, and I swear to do so. But in 1870, I wouldn't have done so. Therefore, we can safely assume that in 2024, you're not going to do so either if you disagree with the law. The proper answer is, if I have to decide, and this is what I would have said, if I have to decide that on the basis of a law which I think is immoral, I would resign as a judge. I cannot find in favor of a law which I consider to be immoral. I would resign. That's the proper answer. But she hadn't thought that one through. And in any case, she didn't really want to resign. But it does show you and highlight the position that Parliament and the making of statutes and laws cannot be the last word. There must be something above it. Again, if we've in any doubt, the Parliament of Germany, the Reichstag, the people elected the Nazi party as a majority party, they formed a government, and they passed a whole lot of laws which are plainly immoral. But that was the Parliament, that was the Reichstag. Are we going to say it is the final supreme authority? Clearly not. There is always an authority higher than man-made law, human positive law. Now, that is what we as Catholics and Christians call the natural law and the divine law and the eternal law. Other religions call it by other names, but everybody who has any serious philosophical belief must see that a parliament cannot be the last word on issues, on all issues, particularly issues of morality. Now, so you've got those two problems which could destroy the superiority and the current very high regard in which the English common law is held worldwide. One, ridiculous statutes, passing laws that are clean contrary to the natural law, divine law, and indeed just common sense. Well, some people would say the natural law is just common sense anyway. Number one. And number two, rights-based law, which introduces the arbitrary into our courts. The combination of those two could be two grindstones, which grinds the English common law and its magnificent tradition to dust and makes it worthless. And they are very real dangers that face us in the present world. And will, with that huge long history and development of common law right the way back to the very earliest of times, back to Anglo-Saxon times, would then be destroyed. And the people who are promoting it, who, it just has to be said, tend to be on the left, do not understand that that is what they are in danger of losing if they continue to press upon the nation statutes and human rights-based law which defies the natural law, common sense, reason, and the divine law. But don't think the battle is by any means won. And since the 60s in this country, we have seen a succession of statutes. And statutes that begin in this country, despite our famed common law system, we have led the way in this, of statutes that defy the natural law and defy the divine law and defy common sense, starting with the Abortion Act 1967 and going on through redefinition of marriage, obscenity, embryo experimentation. Now we've got the Assisted Dying Bill, Mental Capacity Act, and other statutes allowing the termination of life of innocent people. We're beginning to see, having abolished capital punishment for the guilty, people who have committed horrible murders, the introduction of capital punishment for the most innocent people in our society, the absolute pinnacle of the reversal of right order and of the natural law. Now that's happening with statute. Add on top of that this new rights-based law, which introduces the arbitrary into judicial decisions. Who knows where this could go? But you can see that the system that Dr. Phimister and Father Crean have rightly said is connatural with Christendom and with Christian law, common law system, is in danger of being crushed to death by these two millstones. Two millstones, I might add, which do not reflect motivations or sources of law that are Christian, but really the opposite, secularist and secularism. And as somebody once said, secularism is really a dead end, because if it wants to kill off elderly people and not have and abort the child in the womb, inevitably it will not survive. And then something else will move in to fill the vacuum. And it may not be our much treasured common law system or system of equity. It may be something very, very different and very much more oppressive and less fair and just. So we need to understand that we have a treasure here, appreciated by the whole world, particularly by international business and government, that we could end up destroying and throwing away. Not only would it very seriously damage us as a nation, but it would have a very deleterious effect on the rest of the world, who look up to, admire, use, and want to continue to use the English common law system.
Colonel Bogle, thank you very much for a very rich exploration of the history of the common law system from a Catholic perspective. I really have appreciated your insights, and I'd like to thank you for your time. Perhaps we could recommence this interview at another time and address a couple of other points.
Thank you very much. I shall now take my cold off to bed.